My name is Ken Ross. I am SPSP's webinar coordinator, and I'll be moderating the session today and as well as speaking. Thank you all for attending today. We appreciate it. We hope you enjoyed today's session, despite the fact we're talking about something fairly depressing. But I want to thank Cedric Brand Protection, who's sponsoring our 2026 webinar series. We appreciate it, and thank you for your support of this effort. Um, at the end of after the program's over, we will be posting these slides today, plus a link to the webinar. It is being recorded, plus any additional reference material that apply to this product, this subject. And there are some articles that will be posted that deal with this. So you'll have an opportunity to delve into it further. Also, on the last slide, the speakers' emails are there, so you can feel free to email us with an individual question, or if we didn't get to your question during the session. Okay, before we start, I just want to alert you to the upcoming webinars we have planned. February 3, and we're doing it a little bit earlier because we don't want to conflict with the ICFSO conference. So February 3, we've got Geraldine Koch from the UK and Rutger Oldenhouse from Netherlands, who are going to talk about the General Product Safety Regulations technical documentation requirements. And if you are selling in the EU or UK, or you want to or intend to, you need to watch this. This is really very detailed stuff that you have no choice and you need to comply with. Then in March, we're going to talk about customer education programs. We've got one of the speakers is in charge of customer education at Amazon. And we've got someone from the Baby Safety Alliance is going to talk about their customer education programs. So we'll have some speakers who have done these things and hopefully can come up with some good suggestions on how you can do this and when do you do these kinds of things. Then the next in this series will be in April, and I've got Rod Freeman, Ed Turtle, and the other folks from the Cooley law firm who will be giving us an update on the EU and UK compliance and liability regulations and directives and whatnot. I like to do that at least once a year because everything changes over time, and we want to bring you up to date on those things. So that's our schedule so far that I've got planned. Okay, today, as I said, I'll be a speaker and I'll just mention my background in a second, but also I want to introduce Jeff Margulies, who is a partner at the Norton Rose Fulbright law firm. He's in the Los Angeles office. Jeff is both a regulatory lawyer and a litigator, and he'll be talking mainly about the class actions where recalls are involved, which is a growing area and a very important area to be aware of. And I'm going to start off with a discussion of the law in this area. I'll attempt to make it as understandable and interesting as possible. My background is that I became an in-house lawyer many, many years ago, and I had the privilege of defending lawsuits where my company had done a recall and paid the largest fine in the history of the CPSC for late reporting. And I got to defend the product liability cases arising out of that. So I go way back in experience in defending litigation where recalls are involved. Secondly, I have also served as an expert witness for manufacturers to defend the adequacy of their post-sale actions. So whether they reported on time, whether they instituted a recall in a timely fashion, whether they did an adequate job of a recall. So I've served as an expert witness, so I have some insights about what the plaintiffs like to do in this litigation and how easy or hard it is to defend yourself. And the last thing is I have been assisting companies on recalls and reporting and things like that, and also get involved in currently get involved in some products litigation. So I've got a lot of experience in all aspects of this, and so that's why I thought it would be useful for me to give you an introduction to the subject. This is our agenda for today. So we're going to talk first about defending product liability lawsuits. And these where we have individual injuries or deaths, or maybe multiples, but we're not talking about the class actions, which is what we'll talk about in the next segment. Um, Now, these lawsuits and accidents, I'm sorry, these accidents can occur before you have a recall or after a recall. So it's in both areas. And then also talk about some regulatory lawsuits that have been recently filed by the CPSC. So why do we want to discuss this area? Well, one, it is uh, very, very dangerous. This is the nastiest area in product liability, and I think also in regulatory law. Certainly on the regulatory side, as we know, the penalties from the CPSC have been growing, and they have not been shy about assessing, $16 million and thereabouts in civil penalties. I can tell you that in 1982, when my company paid the largest fine in the history of the CPSC, it was $425,000. So it's kind of gone up a little bit more than inflation. So these penalties are huge. Secondly, in product liability cases, a majority of punitive damage awards are based on the failure of the manufacturer to take adequate post-sale remedial actions. And as you're going to see, it is so easy for a plaintiff to argue that if you'd only done a little bit more, I wouldn't have been hurt. And we'll talk about that, and we'll hopefully talk about some ways to defend yourself. Legal requirements to report and undertake remedial programs have expanded both in the US, but also everywhere in the world. So we now have multiple responsibilities. And I think outside the US, even other countries, not much, but I think they have fined companies for late reporting, or no reporting, but that's certainly not as significant as it is here. And the plaintiff's bar knows this. They understand. They read the verdict reports. They see what the lawsuits are being filed. They know what's going on and out there, and so they take note of this, and they will try to throw this allegation into most lawsuits that they bring because it scares the heck out of people, and I'll show you why. So the first of all, let's look at the timeline. The timeline is really important, and it's very different from timeline to timeline. The normal situation is a product's manufactured, the accident occurs, then the company files with the CPSC, undertakes a corrective action, and the corrective action could involve a design change or something like that. Now, the relevant time period when you have the accident is at the time the product was manufactured and sold. But if there's any argument that they can make that you should have reported to the CPSC and undertaken a recall before the accident occurred, and that would have prevented it, that's the typical way that these lawsuits are alleged. But there are also a bunch of other ways it could be. So I just kind of switched these things around a little bit, where the recall, and the first one, the recall is at the end. So there's an accident, the company makes a design change in future products. So they make a running change going forward. They don't do a recall, and then either the CPSC makes them do it or they decide to do a recall. So that's a little bit different. The facts are going to turn out a little bit differently. Also, sometimes you manufacture, you sell a product, and you make a safety improvement. And then you have an accident involving the original product. And then you do the recall. That's even different. So all of these things need to be considered. I don't have to go through all of them here, but how the facts play out are going to have a big effect on how you can defend yourself. And now I'll make it clear because I tried to do this in the announcement. Product safety professionals, we're not expecting you to be lawyers. What we're hoping is that you are aware of this area so that you can help guide the company, and whether it's your in-house lawyer or outside lawyer, guide the company in trying to figure out how to do this so we can defend so we can prevent accidents. Of course, that's our first goal. But secondly, can we defend ourselves later? Can we describe to the CPSC, a jury, a judge, a plaintiff, uh, why we were a responsible company, why we, knew problem at this time, and why we responsibly took corrective actions that were appropriate to the risk that we were aware of. And but it's all, you need to know about this law and how you do this in order to figure out what's the best way to do it. The last one I'll just mention is I've had this recently report to the CPSC because of customer complaints that you're aware of. And then then we're negotiating with the CPSC under a corrective action and a recall. And then we learn about an accident. And then you do the recall. So any delay between the time you're aware of the safety issue and the time you undertake the recall, in many situations, can be many months. And so accidents during that time period are pretty scary.
Ken, if I could just jump in with one comment on
Sure.
these scenarios, and that is that the recall itself may prompt litigation over prior incidents where, there's an injury or a death, the consumer doesn't have any, it doesn't believe or have reason to believe that it's due to a defect in the product. The recall gets announced, and now you have a claim that's surfaced based on something that happened before. And there could be statute of limitations issues, but the recall itself can be a prompt for unearthing claims that might never have been brought before. That's not a reason not to do a recall, but it's certainly something that decision makers need to be aware of.
Right. Now, just a couple of examples here before I delve into the law part of it. Last week, a jury awarded punitive damages against Gree Manufacturing. That's the company that sold the humidifier. Got civil penalties and criminal enforcement against them. So they were in the public's eye a bad player in the consumer product area. The jury awarded over $3.4 billion. That's with a B, against Gree Manufacturing is a jury verdict in a court after a trial. So as I said earlier, punitive damage in most punitive damage cases involve some allegation that that you sold a defective product, but then you knew about the problem and you didn't do anything about it. And we don't know exactly, other than the fact that most punitive damage awards have some post-sale activity involved. You just have to believe that that's when the jury gets mad at you. I do believe, after all these years of experience I've had, is that juries give you some benefit of the doubt when you're designing a product and selling it. They don't when you learn about a safety problem and you don't do anything about it. At least they think you should do something about it. So it's just a bit a different animal that you're dealing with. Okay, so let's talk about. Oops, let me just go over here. So let's talk about the law a little bit. Manufacturers for years have said we shouldn't have any responsibility after we sell a product to do anything. No recall. We don't have to tell the consumer anything. Buyer beware. You've heard that term before. Well, the courts years ago, even before this court, said, no, that's not right. That doesn't sound right to us. We think manufacturers should have a responsibility to tell customers about safety problems that arise, even if they arose after sale. And so that's the New York Court of Appeals, which is the highest court in New York, had this statement that is announced in that court in that case, and it's been adopted in most all states. Not all states. There are a handful of states that have said, no, manufacturer, you don't have any duty to do anything after sale. But most states have some, and many states have different formulations for this law. It's called post-sale duty to warn. We'll get to the recall part of it in a second. So they have different ways to state it, and if anybody's interested, I have a compendium of 50 states and 13 countries talking about what the law is in that particular jurisdiction on post-sale duty to warn. But most states have it, and most states have something that sort of sounds like this. In any event, when we were doing the restatement of products liability in the 1990s, we considered what the law should be. So this isn't exactly what the law is in all states, but this is what we all thought it should be. And basically, that a manufacturer should be required to issue a post-sale warning if these four factors are met on the slide. And all it is a balancing test. It's, well, how high is the risk of harm, and how easy it is it for you to become, to get the message out to the people who bought the product. So it's a balancing test. The higher the risk of harm, easier it is to communicate, the more you should have a duty to do something. Now, this is under the common law of product liability. This is not regulatory law. Okay, which we'll get to that in a second. Now, the problem with this area of law, the post-sale stuff, is that it is independent of an allegation that you've sold a defective product. So a plaintiff can say, okay, you sold a defective product. That's one claim. And the area of law that's governed by is called strict liability. However, in addition, now, presumably you sold a defective product without knowing it was defective. That's okay. You're still liable because you sold a defective product. But even if you didn't know about it, that's all right. But then when you learned about the safety problem after sale, you failed to warn the consumer. Now, that is a different criteria for considering by the court and the jury, and that's based on negligence. And negligence is basically the definition of negligence is a failure to exercise reasonable care. Then jury gets to decide that. And so it is a much more subjective, vague concept than strict liability, which is a little bit more exact and there's a little bit more guidance, but there's really very little guidance on negligence. So basically, if the plaintiff argues post-sale failure to warn, it's under negligence. All they're alleging is, gee, if you'd only done a little bit more, this accident wouldn't have happened. And it's pretty darn hard to defend against something like that, because how do you prove a negative? And now they have to prove, presumably, that your failure to warn or to do something, whether it's recall also, if you had done it, this accident would have been prevented. But in most cases, get settled because the manufacturer or the insurance company is too scared to have a jury say otherwise. Now, I'll give you two examples, and this comes from my expert witnessing phase. I had a client that did a recall of 390 products, and they got back all but two of them. And this was actually an industrial product, not a consumer product. But they mailed the recall letter to all their customers. There were only 390 of them. And the accident occurred later. But they couldn't prove that they didn't have proof that they mailed the recall letter to this industrial customer. And so the customer says, well, we didn't get the letter. We don't know anything about that. Couldn't prove we got him a letter, had to settle the case for many, many millions of dollars. So that is an example how being able to do the right thing and documenting what you've done so later you can show that you did the best you could is very important. Another area, for example, is where you do issue a recall and then you don't do it in a timely fashion. And that's where this negotiation with the CPSC gets into play, and how the extended time, can be many months of negotiation with the CPSC. And if you have accidents during that time, they're going to say, well, you could have done it earlier. You could have done it sooner. You were negligent in not doing that. Even when you do a recall, and they can allege negligence, of course, because they didn't see the recall letter, or they got the recall letter after the accident occurred, which has happened too. So negligence is a very vague concept, that is can be pretty hard to defend. All you can do is to do your best, document what you've done, and hope that nothing happens that will that where they can allege that you should have done things earlier or better or more robustly. Okay. Now, the seller cannot absolve itself of liability for selling a defective product by issuing a post-sale warning. So if you sold a defective product and then you issued a post-sale warning and the accident occurs, again, they can allege that you're negligent because the warning didn't get out to me soon enough, or the warning wasn't adequate in that you didn't adequately tell me how serious the safety hazard was. So as long as the accident occurs, the plaintiffs always have something to say. They can always allege you could do something more, do something more. The one other one from litigation that I can remember is that there was a recall issued, and the accident occurred 7 years after the recall was issued. The company actually took out paid advertising right after the recall was announced, spent hundreds of thousands of dollars on paid advertising. And the plaintiff's argument was, well, you should have had paid advertising for more than 1 month. You should have done it 2 months or 3 months and spent another, $500,000 or whatever, which is ridiculous because the accident occurred 7 years later. So what are we supposed to do? Do recall notices and issue a new recall press release and issue new recall? Anyway, it very, very difficult to argue that and easy for them to say that we were negligent. One last thing from my earlier in-house days. The recall we issued was we had to send out 8 million letters to find 600,000 products. And then I got the pleasure of defending litigation involving accidents occurring after the recall was issued. And that was tough to do. So anyway, so these things happen. This is the problem with it, is that even if you didn't sell a defective product, if you became aware that it was defective after sale, that you can still defend yourself against you defend yourself against selling the defective product, but it's hard to defend yourself on the post-sale issue. So again, what I said was, what's negligence? Failure to exercise reasonable care. Jury gets to decide what they're going to do. There's very little guidance on it, although Jeff, you can tell me if in your product's litigation experience, whether there's more guidance given, but generally speaking, I don't think there's a whole lot they can give you because they use the word reasonable care. And the word reasonable is in the eye of the beholder. So they get to decide, was the manufacturer reasonable knowing what they knew at that particular time? So could they have done more? Should they have done more? And compliance with CPSC requirements may not provide a defense. You can argue that we went to the CPSC, we did what the CPSC told us to do, and that's all we had to do. And that's been my argument as a defense expert, but that doesn't, as a legal matter, is not an absolute defense. In the common law, no duty to recall or retrofit the product, only post-sale duty to warn. However, if the manufacturer voluntarily undertakes to do a recall, then the law is you have to do it reasonably. So let's assume you don't have a legal duty, and of course the CPSC thinks otherwise, but if you just went to do a recall that maybe the CPSC wasn't requiring, or some kind of post-sale corrective action, you've got to use reasonable care, whatever that is. Jury gets to decide that. Also, if you don't recall, they could argue that you should have recalled for punitive damages. So recall gets involved in it, but usually the recalls that we're talking about are occurring because of activity with the CPSC. So last slide here, and then I'll turn it over to Jeff, is here are all the different areas that you've got to consider as you're developing your program before you sell the product and doing things after sale. Post-sale monitoring and surveillance, we've done webinars on that before. We're going to do them again. With that one, that just reminded me of another case that I was involved in. It just settled a week or two ago. A retailer paid lots and lots of money because they had to admit that they did not review online reviews that were coming into their website. They said, we have millions of reviews. We don't have the resources to do that. We do not review online reviews. Online reviews showed that there was a safety issue and an accident occurred. That caused them to settle the case for lots and lots of money. Uh, Now, then you get the information, you do a risk assessment. What do you do? What products are you doing? Are you just making a design change for future products? What about the products in the field? Then you do the products in the field. You do some remedy with products in customers' hands. What do you do? Jeff's going to talk about that and what is an adequate remedy, both from a safety standpoint and also that class action standpoint, which he'll talk about. So how do you document it, and how can we prove later that that we were reasonable and did a good job? Anyway, you cannot agonize over this. You just have to do what is necessary from the standpoint of safety. You need to document what you did. You need to do it as quickly and timely as you can do under the circumstances, which sometimes does take some time to analyze. And and document things and have people who are prepared to testify what you did and why you did it. And that's about the best you can do. But these are important things, and product safety professionals need to be aware of this, I think, to help work with your either in-house counsel, outside counsel, really as you're even doing these things, to be sure that these are things that could be defended later on. Okay, well, Jeff, anything you want to say in response to what I've said, or just jump into your class action stuff?
Let's go ahead and jump into class actions. So thanks, Ken. So there's been litigation, class action litigation over recall products over the years, but in very sporadic kind of in the consumer product world until recent days. And while you may have seen some over auto recalls and things like that, this is still a relatively new phenomenon and sort of an evolution in I'm showing this slide because we're dealing in large part with what we call lawyers with business plans. These are lawyers who are looking to get you to pay them for the privilege of suing you. And back when I started practicing in the 1980s, we were dealing with individual product liability litigation and then even the mass tort cases. But there were a bunch of hurdles that kept making those more difficult over the years. You had to prove general causation, you had to prove specific causation, and you had to prove that the damages were caused in the individual. And that's a lot of work on an individual plaintiff basis. And over the years, the plaintiffs' counsel have migrated. There's been a cottage industry of these folks who have moved to what we're calling these no injury class actions, where they don't have to prove these difficult questions of general causation and specific causation with regard to damages. It limits what they can get, but it makes it a lot easier for them to bring cases. And what they are looking to do, the business plan, as it's been explained to me by one of them, a very prominent plaintiff's class action lawyer, is I want to be able to file a complaint that a judge says makes a plausible claim, and I want to get a class certified on a common question, and I don't ever have to prove that I'm right. I never have to prove the case factually or legally, because your client is not going to want to have the sword of Damocles in terms of the potential catastrophic damages available in a class action, so you'll settle. And by and large, they're right. And in fact, so what you're seeing in top class actions is, this is a website where lawyers advertise looking to get clients. They're out on Facebook as well. They see a recall. So I just got the email today from top class actions. Here's all the latest recalls. They're lawyers looking to get clients saying, did you buy this product? Would you basically be willing to be a plaintiff in pursuing a remedy against this bad company that sold this bad product? So as much as we feel when we do a recall that we're doing the right thing, we've reported to CPSC, we've kind of worked out a remedy, we're a good actor, there's a group of lawyers out there who are just looking for an opportunity to make money off of that, and do it in a way where they're really not interested in winning. They're interested in scaring you into settling. So with that as preface, let's go ahead and turn to the next slide. So what are these no injury claims? Well, they're not I got hurt, and I'll explain why in coming slides. But they are the product I bought wasn't worth what I paid for it because of this defect in the recall. So and actually this is a much broader scope in these no injury class actions. This is not limited to recalled products. The argument is, well, the product's defective or dangerous, so I paid more than it was worth. Claims are false and misleading. The argument can be, well, on your website, you claim you have the safest, juicer anywhere, and it's exploding and sending shards of plastic and metal around the kitchen. So you've made a false representation, and I paid more than it's worth. And then we're also seeing unlawful claims, particularly in California. So we've had a number of claims come in where, a product, a juvenile product, had some level of total organic fluorine in it. And the claim is, well, it's unlawful, and therefore, consumers paid more than it was worth. What are the damages they're seeking? There's this theory of price premium. We are mediating a recalled product case right now where the plaintiff in mediation basically said the price premium was 50% of the $600 average retail price of the product. The fix was a couple dollars. The risk was extraordinarily remote, if there was one, but they'll find an expert who will do some voodoo with a hedonic regression analysis and come up with some price premium. They'll argue full refund. I never would have bought this product if I knew it was dangerous. You need to give me the full retail price of it back. And note that you, as a manufacturer, may have only been able to get 50% maybe at best of the retail value when you sold it at wholesale, but you're responsible for damages at the retail level. So the damages can be extraordinarily high. Ken mentioned, high civil penalties from CPSC. 17 million is the cap for failing to report for a violation-related series of violations. But if you've got a product that you sold, $500 million worth, your cap is $500 million, not 17 million. So it can be catastrophic. Next slide, please. So just a step back, and I don't intend to make this a course of civil procedure, but I just think it's helpful for folks to understand what is a class action. So when we get these cases, one of the questions is, well, the individual plaintiff can make the claim, but can they bring it on behalf of other people who purchased the product? And so typically you'll see classes that are either based on other people who live in the state in which the plaintiff lives, or national classes at times, or sometimes a variety of states. There's a whole bunch of issues that go along with that I'm not going to get into. But typically you would see a class definition that say all people residing in the United States who purchased defendant's product X between the following dates. And that'll, match up with exactly what was in the press release defining the scope of the recall. What do you have to prove to get a class certified? Sufficient number of class members. That's typically looked at as 40. Common questions of law or fact. So, and here the argument is, the defect itself that caused the recall. If it was common to all of the products that were recalled, then you have a common question. Are the named plaintiffs' claim typical of the class, or is there something different about them such that they wouldn't be a proper representative? And are they adequate? In other words, will they adequately represent the class's interests as opposed to their own interests? So all of those four things have to be met. And then one of the Rule 23, this is the Federal Rule of Civil Procedure. Rule 23B, you have to meet one of the following categories. The first is this risk of inconsistent results. That doesn't really show up in consumer class actions terribly often. B2 is where injunctive relief is sought. So you would show that the defendant acted consistently as to all class members. So if the class is seeking a further remedy other than money, they could seek that under this category. And then finally, are there common questions in damages actions? So are there? I mean, do the common questions predominate such that it makes sense and the class action is superior? And this is really where the action happens in challenging class actions in the recalled products world. Next slide. So what kind of issues are we seeing in the recalled products litigation? Have the class members suffered damage? So again, remember we talked about price premium, we talk about full refund. So the plaintiff files a case and says, you recalled the product and I suffered damage. And if there's a cash remedy and you're giving the full amount of the purchase price back, we don't necessarily always get that. I mean, sometimes you negotiate a partial payment back with CPSC. Sometimes you negotiate an average payment back. There could be issues. There could be arguments that the class members or the class was adequately compensated by the remedy. If the remedy is a repair or a retrofit, you can argue that they're not damaged. If the defect didn't happen and the product has been restored to the condition that the plaintiff and the class expected it to be when it was purchased, you would argue that there's no damages. Remember, typical tort claims, so the I was hurt, don't support an economic damage. So you can't bring a negligence claim for just money that you lost the value of the product itself. So you can't bring a class action alleging negligence for personal injuries. You also can't get, so you can't get economic damages in tort, and you can't bring personal injuries in a class action because you'd have to look at each plaintiff or each class member and make an individual trial over whether those damages were caused by the defect and to what extent. So the arguments we do see are cash refund was less than the purchase price, so I'm out of money. You made a repair or retrofit and it's inadequate in one of two or more ways. One is, well, I don't trust your product anymore. I don't want it. That repair is not addressing my damage, which is I will not use this product anymore. And the other is, well, you made me put the retrofit back in there and I had to spend time and effort to do that. We're also seeing claims that the retrofit didn't, the plaintiff alleges and we've got this going in a current case, the plaintiffs are alleging your retrofit is not good enough to do the job of the original component, notwithstanding the fact that the client had to produce testing to CPSC, which selected the remedy among several in the recall. So again, the plaintiff just wants to get a fact question past a complaint. That they don't want to win it. They just want to raise enough doubt that they might get a class certified. Finally, superiority, and there's an early case that talked about class actions not being superior to a recall. If you're having to pay to give notice to a bunch of people where they already have an adequate remedy, this is the superiority argument rarely wins in consumer class action litigation. It's got much better legs, but still I can see judges being a bit reluctant to just decide that the CPSC approved cap was sufficient to address the issue and that there's not reason to let a jury decide the question. Judges don't like throwing out class actions on legal grounds, so it can, again, be a difficult hurdle to get over. And then finally, the one thing you will see, and this the complaint here always comes after the recall. If you recall Ken's earlier timeline, the argument is going to be made that you issued a press release saying there's a defect in the product, so you've basically admitted it. So you can't fight the recall or the class action by claiming the product wasn't defective. I'm sure virtually everybody on this webinar has done a recall, even where they believe there wasn't anything wrong with the product, but they did it out of an abundance of caution or for, customer relations perspective, right? We want to be seen as doing the right thing. And
Well, Jeff, let me just jump in for a second. And generally, thankfully, the CPSC does not require us to utter the word defect in the press release.
right.
Certainly, it can show up in your correspondence, your 15B report, their correspondence back, which in both in a product liability case and I'm sure in a class action case, they can discover that evidence. So if the word defect is being bandied about in those documents, that could be used against you and considered an admission.
But you don't even need the word defect because the press release will say the product can, cause a fire, right? And that's all they need to latch on. So the CPSC does insist that you have to identify the hazard, and by doing so, the plaintiff argues you've basically admitted it. The other issue that can come up is that if you didn't do a fast track and CPSC issued a preliminary determination, that's something that can be a challenge if you're litigating these cases, and that would occur in the product liability scenario as well. The CPSC decided the product is defective. Well, no, they didn't decide anything. It was a preliminary determination. There's a whole regulatory procedure around challenging that. It's not a final agency action, but it doesn't look good, right? It's an optic that, and again, you can argue that it's not admissible at trial because it's not a final decision, but I could certainly see judges letting that in. And then you're fighting the uphill battle. CPSC thought your product was defective, so it must have been. Okay, next slide, please. Okay, so if we want to settle class actions, what do we have to do? So I will say that we are, and then this has been a phenomenon for, at least a good 10 years, that the class actions that are getting filed in court are the tip of the iceberg. Many, many, many claims are coming in by letter and they get resolved privately, and you just negotiate a payoff and be done with it, and they're not settled on a class basis. It used to be that we could settle those relatively cheaply, and they are, the plaintiff's lawyers are realizing that they have a lot of leverage and they're getting very expensive. So we are seeing non-class settlements of cases that are never filed that are pushing $1 million or more. Just because the claim isn't made doesn't mean that you're going to get out cheaply if you get a demand letter. If it's filed, you still have an opportunity to settle individually if you can convince the plaintiff's lawyers that they really have problems with their case. It's hard with a recall because their concern is going to be if they dismiss that somebody else is going to basically take over the class claim, and they'll be accused of violating their ethical duties to the class members. So it becomes much more difficult once a recall is done and a complaint is filed to get it settled without settling on a class-wide basis. And if you want to settle on a class-wide basis, the court has to approve it. And the court has to find that the settlement is fair, reasonable, and adequate. So I've laid out the factors here on this slide about what that means. The big issue is the attorney's fees. The big issue is always the attorney's fees. Every mediation we go into, the attorney's fees are driving the entire settlement. It's all about paying the lawyers. The mediators know it. The judges know it. So they're really looking out for collusion. Are you engaging in kabuki theater where you're, giving pretend benefits to the class? Typically, the attorney's fees can't exceed more than 25 to 33% of the total value to the class. But the courts want to make sure that the class is actually getting the value. So if you are giving coupons to buy new widgets, and that's your relief, the court's going to want to make sure the coupons were actually redeemed in order to approve the attorney's fees. So this is driving the lawyers to insist on just paying a bunch of money. and they want to make sure the money is high enough that some other objector, some other lawyer who wants to make money too, isn't going to come in and say, you're selling the class out. So if you've got a class where, the total value of the products is, $200 million, and you settle for 2 million, there's a big risk that somebody comes in and says, well, of that 2 million, 500,000 is going to the lawyers, another 500,000 is going to pay for the notice and administration, and the class is going to get $1 million of remedy for $200 million of product. That's selling the class out. So it makes it extraordinarily difficult to settle these cases inexpensively. We have successfully so far, although we're still waiting for final approval, in a recall in which the client did we'll either replace your product or we'll give you some cash. We're able to fashion and claim, we were able to fashion what's called a claims made approach, which is, again, a little disfavored because the claims actually have to provide enough value to justify the attorney's fees. And we're able to negotiate a requirement that, or a class settlement, which basically just gave every class member who took the repair in the recall or the replacement product, gave them an extra year of extended warranty, and just valued it at the retail value of what they would have had to pay that. So that allowed us to build up some value. And then those who didn't take the replacement product, we just offered to kick in a little bit more cash, and we're able to do that without getting any objectors to it. But this is really delicate stuff, and you want to be able to do this in a way that doesn't draw objectors and keeps the client's exposure as low as you possibly can if you're going to settle it. Let's go to the next slide, please. So in the specific context of recalled products, I've talked a little bit about this in the last slide. Can you make an argument that the cap and remedy is sufficiently strong that the plaintiff's lawyers really shouldn't spend time and money chasing this class remedy? They're better off taking some money and going away. Bullet 2 is what I've talked about here. Can you find some augmented value that you can give in the context of a repair or replacement that provides enough value? You're still going to have to pay lawyers' fees. You are not getting out without paying the lawyers. And the more lawyers there are, the more you have to pay, regardless of how much work they've done. Fraud is a major issue in class action settlements. Can you insist on proof of purchase? The bigger the product is, the more reasonable it is to insist on proof of purchase. On a $5 product, it's going to be impossible to get the plaintiff to agree to it. But if you've got a product that's been recalled and has significant resale value, can you force class members to participate in the recall and destroy the product before they get a benefit? Because otherwise you're going to pay them cash and then they're going to sell it on eBay or something. Can you insist on recall participation generally to avoid fraudulent claims? What can you do about the cash remedy in a recall to potentially limit the value of the settlement? The other thing we talked about briefly is this concept of injunctive relief and having to take action in the future. I would argue that the recall is the government expert agency's best assessment of what is needed to do to address the alleged defect on a go-forward basis, and that there shouldn't be a need to have to agree in a settlement or otherwise to any other action addressing the alleged defect. That really it should just be about money and trying to settle the class as expeditiously as possible. Okay, next slide. So let's step back. Ken, next slide, please.
Oh, sorry.
Yeah,
Oops.
no worries.
A second there. There we go.
So what can you do? So you're negotiating a cap, and should you be thinking about there's a recall coming? Yes, not a recall, but once I announce the recall, am I at risk of a consumer class action? It's probably good to be thinking about it. What can you do when you're negotiating corrective action. We'll understand what the arguments are going to be made in a class action. Your recall notice wasn't sufficient to reach all consumers. Ken already talked about this in the context of a product liability claim. I didn't get that notice. So think about that. You're kind of constrained in terms of what CPSC is going to insist that you do in notifying it. I'm not suggesting that you hire somebody to do a Google Ads search or Google ad placement or a Facebook ad placement, but understand that may be an argument. If you're paying cash less than 100% of the retail purchase price, that's a red flag for plaintiff's counsel. And I understand that, when we are negotiating recalls, our clients really don't want to pay 100% if they can avoid it. But the less you pay, kind of the more you're increasing the risk that somebody will be upset and make that argument later. We talked about the inadequate repair or replacement. So that's something that, if there's some argument that can be made that the repair is not adequate, or the replacement is going to be, if you're dealing with a product that causes fire, if you're doing a repair or a retrofit or a replacement, you may run into this situation. Or if you're asking the consumer to go do the work to do the repair, that can be an argument. So all of these things I'm not suggesting there's an answer to them, but they are things that you can keep in mind as you're negotiating corrective action.
Let me just jump in on this. I did a recall years ago where it was $1,000 product. That was the retail price. CPSC wanted me, and one of the parts on the product was defective, and we wanted to replace that part. That part cost us 50 cents. CPSC wanted us to offer a full refund of $1,000 per product. And I said, hell no, we're going to replace the product that needs to be replaced, which was really cheap. Now, this was well before consumer class actions became a little bit more popular, but it seems to me it's very hard. I mean, sometimes you're going to get these stark differences between a repair, a minor repair, a replacement of a part, and a full refund. And I guess I would say, from my perspective at this moment, is you can't let the threat of class actions drive you to spend millions of dollars or hundreds of thousands of dollars more to offer a full refund when a repair or replacement really will do the trick. I mean, I think you want to think through how you're going to argue that it is adequate. But as Jeff said, these guys they'll send you the letter or file a lawsuit, which is real easy. It's a template on their computer. I mean, they can get it on file. And I've had class actions filed 3 days after the recall was announced. So it's real easy to do. And then just hope you throw money at them, and they've made gobs of money for doing nothing. But you want to, so I worry about this when I advise a company, let's do a repair or replacement, but I sort of have to tell them, there could be a class action, but I'm not going to tell you, you really need to do a full cash refund because it's so much more expensive.
That is the rub. That is exactly the rub. So it may be that the best you can do is educate, decision makers that if you do this, there's a risk that we're looking at, this class action that may be far worse at the end of the day. And there may be nothing you can do to avoid it.
Right.
Okay.
You got one more slide?
We get one more slide. So we were going to talk briefly about civil penalty cases brought by CPSC. And you all probably have seen that within the past month, CPSC filed, or the Department of Justice filed, a case against Black & Decker seeking civil penalties, excuse me, sorry, over utility bars and miter saws and failure to report. Why do they file these penalty actions? Well, they feel like they need to make examples of people. The max penalty is not making a dent in the U.S. deficit. It's more, from my experience, about trying to identify who CPSC thinks are bad actors, getting them in court. These are cases that there have been negotiations over a penalty, and the negotiations have broken down. that's they don't get filed, kind of without having extensive back and forth on a potential settlement. And they it used to be back in the day that the compliance department would refer a matter over to general counsel's office after the recall. Now, my experience with the trial counsel embedded into compliance is that I think they're looking at this issue in real time as you're dealing with them with initial reports and corrective action negotiation. I don't know if you've got a similar vibe, but I think we kind of get that sense when we're talking with them.
Mm-hmm. Yep.
What relief can they get? They can get civil penalties with the $17 million cap per related series of violations. They have been seeking injunctions too, where they believe that companies do not have adequate product safety compliance programs. And there was a lot of litigation in the Spectrum Brands case over what the compliance looked like. They have sought and won getting a company to pay for a third-party monitor where they don't trust the company to implement, excuse me, the plan. And the courts have approved that, where the showing was in the court's view sufficient to justify having a monitor. How have they fared in court when they brought civil penalty lawsuits? Well, they haven't brought that many that have gone to judgment. They have not gotten what they've asked for generally. I think in Spectrum, if I'm recalling correctly, I think they asked for like 12 million and got something like $1.5 million. Back in the first case involving the Marama juicers that I had the pleasure, I guess, of trying, they asked for 600,000 and were awarded 300. So I think they have not obtained kind of the level, by and large, of civil penalties that they've sought. But there's a lot of value to winning a case. I mean, the interim value in the industry writ large of seeing CPSC willing to refer cases out to DOJ and take them into litigation that's expensive and ultimately prevail is what they're looking to make you aware of and think about. And what does the crystal ball tell us? I mean, I think we're going to see more cases threatened, if not actually brought. I think they are looking to continue to make examples of company.
Okay. All right. Thank you. I have on this slide where you can email us or the speakers with questions and how you can get the slides. I want to mention that the Society of Product Safety Professionals will have a booth in the exhibit area at ICFSO, where you can learn more about our organization and programs. And also, we have a reception on Monday, February 23 at 5:30 p.m. At the ICFSO meeting for anybody who wants to come. You don't have to be a member of SPSP to come, but please come by and find out what we're all about. And we appreciate you all participating today. And again, you'll have a lot of material you can look at if you want to, or you want to send over to your in-house lawyer if they want to take a look at this. This is unfortunately fairly legally related, and so it's easier for product safety professionals to try to figure out how to prevent accidents. It's a little bit harder when I tell you. You also want to be able to defend yourself, and that's kind of like, well, to who? Who am I defending myself against? So that's a little bit harder to figure out, but I think some of the articles that will be posted will give you some guidance on that and some suggestions about what you can do. So hopefully you all understand how important of an area this is. So something we cannot take lightly, and we'll look for more material when it comes in the posting, and hopefully we'll have new webinars also, which maybe drill down even further on some of the narrower issues. And oh, and by the way, send an email to me if you want, if there's a particular topic within this subject or just in general that you would like to have us consider presenting a webinar on. I'm still open for suggestions, so appreciate it. Again, thank you all very much for coming today. Hope you have a good day.